proposed to the county commission, and they approved it unanimously. I read it again during the campaign, and then I've read it again multiple times in preparation for this hearing. And I've also read many of the objections and concerns raised by citizens within Nassau County, different op-eds, things that have been written online, comments made at other workshops in the county commission meeting. And I want to just touch on those, even though you've addressed a few of them. Specifically on page 68 of the bill, with regard to eminent domain. Once again, am I correct that any eminent domain authority exercised by the stewardship district must be approved by the county commission?
Any eminent domain authority exercised by the district outside of its boundaries has to be approved by the county commission. The district does have authority, as do CEDs under general law, to exercise that authority for specific purposes within its boundaries. And historically, that was one of the indicia of governance that was included within Chapter 190 and previous bills from an IRS regulatory perspective. That's an indicia of sovereignty. But it is unusual for districts to exercise those powers, but you are correct. Outside of its boundaries, it must be at the consent of the county commission.
And then on page 84, paragraph P, the pledge by the state to the bondholders, is that just a guarantee that the state won't come in and change the terms for the bondholders? Can you elaborate on that provision a little bit more?
Sure. It is actually implementing the provision of the Florida Constitution, which is Article 1, Section 10, which states that no law shall be passed impairing contractual obligations. So the language itself is drawn from Chapter 190, and that language is actually consistent with what you see in Section 190.016 relating to community development districts. It is intended to implement that constitutional prohibition, and it does intend to give some comfort to those who are going to buy the bonds that are ultimately issued by the district, and those buyers are, State Farm, Goldman Sachs, those kind of participants in the capital markets. But that is implementing that provision, yes.
And is the language used within the bill standard language with regard to bondholders? Is there anything unique about this language, or is this common practice within the bondholder market?
It's standard language. Not only is it consistent with Section 190.016, if you look at the other stewardship district bills, Lakewood Ranch, Babcock Ranch, you'll see that same language.
And lastly, there's been some question about either the constitutionality or the legality of the stewardship districts. I did extensive research last night, and I cannot find any appellate court cases or any Florida Supreme Court cases addressing either the constitutionality or legality of the stewardship districts. Are you aware of any case law addressing or contesting the legal authority under state statute for the stewardship districts?
Sure. There is a Florida Supreme Court case that I think predates my law license that addresses the constitutionality of Chapter 190, which was, in essence, the form which we draw upon and apply over a larger canvas. That was the Frontier Acres case. I wish I carried those kind of case citations in my head, but I don't. So many of the provisions of this bill, the 1 acre, 1 vote, taxing authority, assessing authority, those things were litigated in the context of Chapter 190 when it was shortly after it was enacted. At the appellate level, you won't find decisions. However, each of those stewardship districts that we've referenced before, before they issue bonds, after the district exists, we have to undertake what's called bond validation under Chapter 75 of the Florida statutes. And in that proceeding, we file a case in circuit court to say that we wish to issue X amount of bonds for Y purposes, and ask the state to agree that, the judge to agree that we have followed appropriate procedures and that we have the legal right and authority to do so. The state attorney represents the other side, the citizens of the state, in litigating that case. So we do have a number of circuit court decisions in which the court has said, yes, indeed, stewardship districts with substantially the same legislation were legal, valid, binding, constitutional, etc. And would be happy to provide those.
Thank you very much.
Mr. Chairman,
Yes.